And now that we're just about ready, Ike Elmo would like to say a few words regarding University House Wallingford and our speaker today. Thank you.
Thank you, Elliot. Hello, I'm Ike Elmo. As many of you know, University House Wallingford has a unique partnership with the University of Washington Retirement Association, the UWRA. This relationship gives our community a distinct academic flavor where residents enjoy a connection to UW programs and a commitment to lifelong learning. As an Era Living community, our residents benefit from the partnerships developed with the University of Washington School of Nursing, Social Work, and Pharmacy to deliver innovative programs designed with healthy living in mind. We are pleased today to have with us Janet Smith, who has joined us today to present on a timely topic, the power of planning. Janet Smith, founder of Northwest Elder Law Group, is an attorney providing services in elder law, estate planning, estate administration, guardianship, trust and estate disputes, and elder mediation, and she's been licensed in the state of Washington since 1983. Please welcome Janet Smith.
All right, take it away, Janet.
Hi, everyone. I'm so glad to be doing this today. And it's really great that all of you are being lifelong learners and experimenting with what Zoom is all about, and that we don't have to be in person in order to keep learning from each other. So I think that that's great. What I'm going to be talking about today is planning in the sense of what generally is called estate planning documents, wills, powers of attorney, things like that. I will be hopefully leaving some room for questions at the end, and Elliot's told you how to submit those questions. We may not get to all of your questions given the amount of time we have today, so I wanted to say that we have a lot of content on our Northwest Elder Law website, and that will be in the contact information that you receive, or you can find that at nwelderlaw.com. So we have a lot of articles and blog posts, and some of those may answer your questions if I don't get to everything that was on your mind today. What I'm going to be focusing on today is, first of all, in terms of what's going on right now, how do I update my estate planning documents in this time of restrictions and shutdowns. I'm going to talk about how to simplify what you've got. If you did your estate planning 20 or 30 years ago, your life circumstances were different, your assets may have been different, maybe you've got more complexity than you need. So we're going to be talking about that. I'm going to be talking about how to make sure that your wishes are current, and especially how to choose the right people. Estate planning documents name the people that you want to serve in particular roles, and it's very important to name the right folks for that. And finally, I'm going to talk about how to make it easier for the people that you name as your agent or as your personal representative on your will. So first of all, going back to how do we do this in the current time? We are working full-time here at Northwest Elder Law Group, and we are working as remotely as possible to get estate planning documents either done for the first time or updated. So the way we do that is that we have a questionnaire that we have you fill out, and then we get that back, and we set up our first appointment either by phone or by Zoom, just like this. It's kind of nice to do it by Zoom so that we get to see each other. And so we do all of that information gathering and answering questions and getting everything sorted out without any in-person contact. Then we prepare your documents, we send them to you for your review, and only when the documents have to be signed do we have a brief in-person appointment. Unfortunately, the law lags behind other things like buying real estate. There's no option for DocuSign or electronic signatures for legal documents, and wills need to be witnessed by two people. So we have our office set up to be as safe as possible. We wear masks, we have plexiglass, we keep that appointment really down to 15-20 minutes. So it's pretty much the same level of safety as going to your doctor's office. So that's the way that we are working right now to get your documents done. So the next topic I want to talk about is simplifying. And one of the things I really miss about not being in the same room with all of you is I love to be interactive and I love to ask questions and have you all raise your hands. But you know, we can't do that right now. But many of you might have done your estate plans 20 or 30 years ago, and one of the really significant changes that's happened in that time has to do with the estate tax. If you did your will or a trust back in the 1990s, if you can believe it, estates over $600,000 had to pay estate tax. And those numbers are kind of shocking today. The federal limit for estate tax, the exemption, is now $11 million. We don't see a whole lot of people in our office who have, and that's per spouse. So we don't see a lot of people in our office who have that kind of wealth. But even Washington State has an exemption for estate tax of $2.2 million. And so if your estate is less than $2.2 million, you may have a will that includes all kinds of estate tax complexity that we could just wipe off the books and get rid of and make that easier for your personal representative to deal with. The other thing that we see a lot when people last did their estate plan 20 or 30 years ago, their children might have been minors. So they don't name their adult children in roles such as an agent on a power of attorney or personal representative, because their kids might have been teenagers at the time. And so it is important to keep the documents current, because the people who you're going to call on to help you at various times are going to change over time. And we want to make sure that those choices are correct and current. So talking right now about your will, one of the questions that comes up almost every time I do one of these presentations, and it has to do a lot with people who especially are interested and read a lot of articles, and maybe they read Susie Orman's columns on finances. And Susie Orman is very emphatic in her advice that everyone in the world needs to have a revocable living trust. And what a revocable living trust is instead of having your assets controlled by your will after your death, a revocable living trust is like a container. And you put things in the container. You put your assets in the container, and the rules that govern that container are what govern your assets. The reason why Susie and other people in states like California recommend revocable living trusts is because it's a way to avoid probate. Probate is the legal process that happens after your death that governs how your debts are paid and how your assets are distributed. And in some states, and California is one of them, probate is a big hassle. It's expensive, it's time consuming, it adds layers and layers of complexity. And so people will spend money to avoid the need to go through probate. Washington State is not that way. Washington State has a really, really simple, streamlined probate process. So for the vast majority of our clients, it doesn't pencil out. It doesn't make sense to spend the money and the time to create a trust and to create all the rules about how the assets are going to be governed, and then to take all of your assets and put them in the trust. Because for real estate, that involves doing and recording deeds. You have to put your property into the trust. For most of our clients, if they don't already have a trust, it doesn't pencil out. They're not going to save enough time and hassle to make it worth it. So for most of our Washington clients, we recommend just doing a will. A will is a perfectly good vehicle to take care of disposing your assets after your death. Now, a lot of the folks that we meet who have moved here from other states, like California or Arizona. Now, you may already have a trust. That work may have already been done. And so in those cases, we take a look at whether that trust simply needs to be amended to add a charity, to change a person, to change the trustee, to make some minor changes. So if you have a trust, we work with that. But if you don't already have a trust, we're probably not going to recommend it. Again, unless you own property in one of those other states like Arizona or California. If you have a second home in another state, then we're gonna talk about the pros and cons of trusts. So your will is really easy to update. It doesn't have to be a complicated document. It names who your family is. It names who you want to be your executor, which is another word for personal representative. It says what you want to happen with your assets after your death. And so we like to help people update their wills to make sure that they're current, and that they name the people or entities that they want to receive their assets. Now, the next document I'm going to talk about is the power of attorney for finances. And in the real world, this is the document that I personally think is the most important document that every adult should have. And I say this so often at every presentation. I sometimes get clients bringing their college student kids into the office to get powers of attorney. I just did that this week for a family. The daughter's 20. She's going back to school. Whether she's going to be in school or not is yet to be seen, but her parents thought it was a really good idea for her to have a power of attorney for finances and a power of attorney for healthcare, so that if anything happens to her, she has somebody who can make healthcare decisions for her and someone who can make financial decisions for her. So we recommend these documents to everybody. There is no one who cannot benefit from having a power of attorney. It's a lot like having hazard insurance on your house. None of us go through life expecting that our houses are going to burn down. It's a very rare occurrence, but if it happens, you need to have had that insurance in place beforehand. So a power of attorney is a lot like an insurance policy. You may never need to use it. You may never be incapacitated, and we hope that that's the case, but it's a really, really vital document to have. Sometimes people say, well, I don't need it because I'm married and my spouse and I, all of our assets are joint. Both of our names are on all of the assets. It's just, I don't think it's really necessary. My answer to that is it is necessary, because the financial power of attorney covers a lot more things than just your bank accounts or your house. It covers things like insurance. If your spouse is incapacitated and you're calling the insurance company to try and sort out an explanation of benefits. They won't talk to you without a power of attorney. In another case, I'm working with a family getting some long-term care insurance benefits. Well, the daughter had a medical power of attorney, but didn't have a financial power of attorney, and she couldn't sign the forms to get those benefits as direct deposits for her mother. So a durable power of attorney for finances is very, very broad. It covers basically everything financial or legal, and it gives somebody the opportunity to act in your place if you're not able to. We like to make sure that you have named the right person for that job. That's a very important job. Sometimes, you know, we look at this on a case-by-case basis. Sometimes it might make sense, believe it or not to name your spouse. If your spouse is perhaps having some difficulties of their own with managing a checkbook or managing day-to-day activities, that might not be the person that you want to name to take over all of your financial management if you were to suddenly have a health crisis. That might be the time to say, you know, let's just be realistic here, and let's put the son or the daughter on the power of attorney, because, you know, if I were to suddenly be hospitalized and have a health crisis, that's going to be a lot of stress on my spouse anyway, and I want the right person to be able to make those decisions. We also talk to people to be very realistic about their kids, because this is not naming someone for one of these jobs, whether it's an agent on a power of attorney or whether it's executor of your estate. These are jobs, not privileges. And so sometimes we hear, well, you know, my son Johnny would be really upset if he wasn't named on my power of attorney, but I'm not sure I trust him because he does have a gambling problem. So yeah, you know, don't name your son who has a gambling problem or an alcohol problem or is just really, really bad with money to handle your affairs when you're unable to do that yourself. Birth order doesn't matter. Name the person who is right for the job. We get a lot of questions also from families, single or couples, who say, I don't have kids, or I don't have kids that I would trust with those jobs. What do I do? And that's a pretty common scenario. And the answer to that is that in the old days, attorneys would sometimes serve in that role. Most attorneys now will not, and the Bar Association doesn't like us to do that. That's kind of mixing roles. But there are professional companies, and they are called professional fiduciaries. And you can look them up online. For most of our clients, the larger banks and trust companies really are set up to help people of high net worth. They want minimums, sometimes as much as $2 million in asset management before the banks or the large trust companies are going to want to work with you. But there are companies that work on an hourly basis, fee for service, and they don't have a minimum. They will work with anyone. They do charge a fee, but they charge on an hourly basis for what they do. So that's who you can name in your documents if you don't have a family member or a close friend that you want to give that job, that task to. So that's an important way to go. For the power of attorney for healthcare, we frequently name more than one person, because doctors are pretty used to working with family systems. And so Well, the financial power of attorney, it's probably going to be better to say, I name A. If A can't do it, I name B. If B can't do it, I name C. Because the banks and the financial institutions really want to know where does the buck stop? Who are they dealing with? But for the medical power of attorney, it's not at all uncommon to name your spouse and your kids. I name A or B or C to be my healthcare agent. And so that way, any one of them who was available and able to make a decision could step in and make a medical decision. I have to say that this is a little strange because I would probably stop, at this point and ask people how they were doing, check in with my listeners. And so I hope you're all doing okay. Another way that we can simplify our financial affairs is making sure that we have checked and double checked your beneficiary designations. Beneficiary designations are extremely important. And a lot of times your largest asset might be your either an IRA, a 401k, or a brokerage account. And you can name who's going to get that account after your death simply by naming a primary beneficiary would be your first choice. And if that person has died before you, you can name contingent beneficiary. So you might name, this goes 100% to my spouse. If my spouse is not alive, it goes 50% to my son, 50% to my daughter. Very, very easy to do. And those assets then don't have to go through probate and simply go to that beneficiary. We like to make sure that people have updated their forms so that they are current, and they go in the percentages and to the people that they want. And the backup to that, now you can't name as much, can't give as much control through beneficiary designations as you can in a will. For example, if you want a beneficiary to not have access to their inheritance until they reach a certain age, that's something that you would want to do in a will. Or if you needed to create a trust for a disabled beneficiary, that's something you'd want to do in your will. But beneficiary designations are very useful, very simple, and especially if you no longer own any real estate. So if you have sold your home, put that money in a brokerage account, move to University House, it's possible you might not have to go through probate at all if all of your assets have designated beneficiaries. And so that's something that we like to go over with people to see if that's a way that we can simplify. Question we get quite often is, where should I keep my documents? One of the things I'm going to give you all homework right now, and that is, if you have estate planning documents, double check that you know where your originals are. Because sometimes we do these, we set them aside, and we have no idea where those originals are. And legal documents, again, this is a lot of things about the law are very old-fashioned, but having those originals matters, particularly for your durable power of attorney for finances or your will. The original matters. So your homework is to check and find out where did I keep these, and have I told the person who would need to know where I keep these originals. So say you have a power of attorney that names your son who lives in Chicago. Does your son who lives in Chicago know how to find that original if you were to have a health emergency and he would need to step in and start making decisions for you. So that's a really good thing. We don't necessarily like the idea of keeping legal documents in a safe deposit box. The reason for that is that safe deposit boxes are a cumbersome process to get those out again. You can put somebody else on the box, but that person then needs to physically go and retrieve the documents. So say your son in Chicago is your agent and you have your documents all locked up in a safe deposit box, and he's the only other person that can get into that box. He would have to physically come to Seattle in order to retrieve those documents. That might not be the best thing, as opposed to you keep them in a filing cabinet in a secure location. Someone else could be authorized to go and get those originals and FedEx them to your son in Chicago or something like that. So we recommend picking a safe place to put your documents, but probably keeping them at home in a filing cabinet or in a notebook on a shelf, or the drawer where you keep your passport, or something like that. Okay, I'm going to move on now to talk about advanced directives and post forms. So I think a lot of people have a lot of questions about how these documents work, especially in this time of crisis where we weren't necessarily, I think prior to this, most of my clients had no expectation that they would ever have a question of whether they needed to be on a ventilator. That's something that has entered our lexicon in the last 6 months, and now people are concerned about it. So the way that an advance directive to physicians works, this is a future tense document. This document states your wishes only for that time of life when you are either dying, you're in a terminal condition, or you're in a permanent unconscious condition that the doctors believe there is no hope that you're going to come out of. We don't use the term coma in the documents because a coma is often not a permanent condition, but we say permanent unconscious condition. Or if you are at the end stage of a debilitating illness, such as ALS, Lou Gehrig's disease, or MS, or something like that. So if one of those permanent scenarios exists, and you are not able to speak for yourself and say what you want, then the document gives your instructions generally about certain kinds of treatments that you would not want at that point, that you would not want to unduly prolong the process of dying. And so there's generally places on the document to indicate whether or not you would want to be on a ventilator, whether or not you would want CPR, whether or not you would want artificial tube feeding or tube hydration. So those are generally the kind of questions that you're going to be asked. But that is, again, just a future document. It's not going to have anything to say about if you get sick next week and the doctors are recommending a ventilator to save your life. The advance directive is not going to have anything to do with that. Now, the other form that folks who have moved to a retirement community are generally aware of is the POLST form, P-O-L-S-T, and those letters stand for physician's orders for life-sustaining treatment. And it's sometimes also referred to as the green form because it is printed on lime green cardstock, sort of Seahawks green. And so it's very, very visible and very obvious when that form is in your home or in your chart at a community. This is the present tense document. It replaces the old do not resuscitate form. And this document says, if I have a health crisis today, this is what I want to happen. And this is where you can specify that you don't want everything to be done. Now, who needs a POLST form? Generally, it's considered that if you have either a life-limiting illness, so you have a diagnosis of cancer or Parkinson's or MS or Alzheimer's, that you should have a POLST form. Or if you have reached an age where your medical providers would not be surprised that you died of natural causes, those are the people who need to have a POLST form. If you don't have any illnesses that are likely to cause you to die in the next year, and you're at an age where you still want them to do everything for you, then not having a POLST means you get the default setting, which is call 911, have the firemen work on me, do everything. So generally the people who want the form are the folks who have decided, you know what, at my age, I don't want CPR no matter what. And then you fill out that form. You get that form. That form is not a legal document. That form is a medical document. And you get that form from your doctor. And you fill it out in consultation with your doctor. Your doctor can explain what are the ramifications if I say I don't want CPR. What are the ramifications if I say don't ever put me on a ventilator? Things like that. And so you and your doctor sign it. And what's really cool about that is that because it's physician's orders, then the first responders have to follow it. The first responders do not follow an advance directive. If 911 is called and someone's waving your advance directive in their face saying, she doesn't want CPR, they will ignore you because they don't read legal documents. They only can follow medical orders. And so if you are at a place where you do not want CPR, you do not want hospitalization, you do not want interventions, that's when you need to have the green form signed by you and your doctor. And it's generally recommended that you, if you're in a assisted living community, the community generally has guidelines for where those are kept, whether it's in your chart at the front desk, whether it's in your apartment, whether it's in your freezer, or whatever. If there are no specific rules where you live, then the fire department suggests that you keep it either taped or with a magnet on the front of your refrigerator. And the reason for that is it's always easy to find the refrigerator in any dwelling. There's usually only one. And because it's on that lime green cardstock, if 911's been called, they come rushing into your apartment, one of the 6 firemen is going to look over at the refrigerator. And if they see that flash of lime green, then they're going to say, wait, we got a POLST, let's see what it says. So that's why they recommend putting it on the refrigerator. The other place you can put it is if you are someone who is in a condition where you're spending most of your time in bed, then it can be taped to the wall in your bedroom. So that's where you keep the POLST form. Okay, moving along. We've talked about being current. We've talked about simplifying. Now I'd like to talk a little bit about organizing and sharing information. Um, a lot of times when families say that it was really, really difficult to deal with a parent's death or a spouse's death, what they're really talking about is that they encountered a mess, and that the papers couldn't be located, that they didn't know where the bank accounts were, that things kept coming in the mail that weren't expected, um, that it just generally, no one had given them a guidebook on how to do this. So we recommend, and it doesn't have to be in any particular format. There are lots of products out there to help you get your information organized. Or you can just make a list. The first thing you should do is make a list of what financial institutions you have accounts at. Even if it's that little $5 account that you used to have but you never quite closed, maybe that $5 account is at a bank where you have your safe deposit box. Make a list. Where do you do your banking? If you have a safe deposit box, make a list of what's in it and make sure that someone else is on that box and that the person who's also on the box knows where to locate the key, because that'll save you hundreds of bucks right there, so that somebody doesn't have to pay to drill into the box to look for something that's not there anyway. They're looking for your will. Well, maybe it's in the safe deposit box, can't find the key, but they still have to look. So make a list. Make a list of where, and maybe you want to email this to your family member. Make a list of where you keep all that important stuff. Where do you keep your passport? If you're a veteran, where do you keep that? And I forget the number of the form, the DD whatever, the discharge form that might be important for applying for veterans benefits. Where do you keep, if you are a widow or a widower, where do you have a copy of the death certificate for your spouse? So just, make a list of where you keep that important information. I think it's a good idea to share information with, if you have named a family member or a friend to take over as your power of attorney. I think it's really important to share a basic snapshot of your income and assets, because a lot of times families are very private about this, and kids are left wondering, I don't know if mom can continue to live where she's at. I don't know if she's going to have to sell her house. They might not even know that you get 3 pensions from prior jobs and your income, you're doing just fine. So I think it's really good to get past that hesitancy that we have about talking about financial issues, and share the basic information that your family's going to need to know, so that if they did have to step in an emergency, that they would know where to find stuff, and they'd have some idea of what your income is, what your assets are. If they don't know that you have undeveloped property in New Mexico, they're going to be really surprised when they get a property tax bill and don't know what they're paying. So be organized and share that information. Another thing that we talk to families about, and we get a lot of calls as an elder law firm, we get a lot of calls from adult children who are concerned about their parents. They don't know how to help if they're noticing some decline. And we talk to families about being proactive about getting a little bit of help when you need it, and not being that proud, stubborn parent who simply says at all times, no, no, no. I don't need any help. I don't want you to help me. I don't want to give up my car keys. Get out of my business. Those are the situations that can get difficult and expensive and create a lot of conflict, and that we do recommend sharing the burdens a little bit. We recommend to all of our clients that their durable power of attorney for finances say that it is effective immediately. Now, it used to be a lot more common for those documents, and many of you probably have them that look like this, that says this power of attorney does not take effect until one or two physicians certifies in writing that I can't manage my own affairs. Okay, so here are some of the problems that kind of a document can create. We've seen situations where a parent is starting to have some slipping memory, not doing real well with the checkbook. Son is named on the power of attorney, but can't even get any information from the bank because there's no doctor's letter. And mom doesn't want to go to the doctor. And so you have a dilemma of how do I get a doctor's letter if mom doesn't want to go? She doesn't want to go because she doesn't want the doctor to write that letter. It can be embarrassing. It can be difficult. Then you have the doctor who says, oh gosh, I don't want to write that letter. I only see Jane for 10 minutes every other year. How could I possibly know if she's able to manage your checkbook? And the doctor then wants to send you off for a full battery of tests and doesn't want to write the letter. So these letters are difficult to get. We don't like doctors messing with legal matters. You are actually more protected if you have a power of attorney that's effective immediately. It's like an extra set of keys. So I can give my employees a key to get into the building on the weekend. That doesn't mean I've given them permission to come into the building on the weekend. It just means I've given them the key, and I either have to tell them that they have permission to come into the building, or the circumstances have to be obvious. I'm incapacitated and someone needs to go into the building to get something. So your power of attorney is the same way. You can have the document be effective immediately, but you tell your son or daughter or whoever's named, I am not authorizing you to do anything with my affairs. But if I give you permission, if I delegate to you, or if it is obvious from your observation of me that you need to step in and do something, then the document is ready for you to go. And if you don't trust the person you're naming enough for them to honor that, then they're not the person that you should be naming. You should be naming somebody that you do trust to follow your wishes and to stay out of your business when you're asking them to stay out of your business. But we have found that having the documents that are effective immediately are far more useful, far more effective, and prevent a lot of difficulties down the road. Okay, we're about at 11:15. And so I would like to open it up to questions. If there are questions about things that I've talked about or things that I haven't talked about, and you can add those in your chat, or you can email them. Let's see, we have quite a bit of chat.
Mm-hmm.
Okay.
I've been writing these down in the order they've been coming in. So it looks like so far we've got 3 questions and a comment. So I'll just start at the top with the first question. They wondered, how onerous is the Washington estate tax?
How onerous is the Washington estate tax? It is not very onerous, okay? So first of all, the first $2.2 million is exempted. So there's only going to be tax on the portion over that. The tax on the next $1 million over that is a 10% tax. So to kind of put it into a framework, if you if you die and you have about $2.5 million, your after you pay all of your expenses and debts and all of that, you know, you might be writing a check to the state of Washington for $30,000, and your heirs are going to get, you know, the 2.2, 2.3, $2.4 million. So it's really not an onerous tax. One of the things that you can do in Washington, if you are at a point in your life where you absolutely know that you have enough money to take care of your own needs, Washington does not have a gift tax. So if you know you've got enough money and want to would rather your heirs get that money rather than the state of Washington, then you can start giving it to them in large amounts. There is no tax penalty for giving your heirs $100,000, $200,000. That annual gifting rule that everyone seems to know about of $15,000 a year, that's a federal rule. And that would only affect estates of more than $11 million. So you can make large gifts if you want to reduce the size of your taxable estate. It's something nice about Washington.
Thank you, Janet. The second question is, what if the health power of attorneys disagree?
So one of the things we can do is, if you have agents that you think are not always going to be on the same page, but you still want to name more than one, you can put in a tiebreaker. So you can say, you know, my three kids, you know, and usually when they disagree, it's always not, it's always an even number. So you have four kids, and two of them think one thing and two of them think the other. You can put in a tiebreaker of who's going to, you know, have the trump card. But medical providers are also pretty good at getting folks to reach consensus on a medical decision. So if it's, sometimes it's just a matter of education. One family member might be having a harder time accepting a diagnosis or something like that. But I think if you seriously think that your healthcare agents are going to disagree a lot, then it's better to just name one person who will consult with the others and then make the decision.
Thank you. Another question related to the pulse that you talked about earlier is one person was wondering, are pulse exclusive to Washington state, or do other states require pulse as well?
I think that every state has their own version of it. It may not be called the same thing, but you can check with the medical association of that state. That's generally where you can find out what their form looks like. And I don't think that any state requires it. It's really something that is available to you if you want to make a medical instruction that would be similar to a do not resuscitate.
And a follow-up question to that is, if someone moves from another state to Washington or vice versa, will their pulse apply, or do they have to have a new one in the new state?
I think that, so first of all, the question I often get is about the legal documents. If I did my will and my power of attorney in another state, will they be effective in Washington? And the answer to that is a very simple yes, because we have going back to high school days, you have the full faith and credit clause of the Constitution, a document that is created in one of the 50 states that was valid where it was executed will be honored and accepted in any other state. Now, that being said, for the pulse form, this is something that is going to be often used in an emergency situation or in a life and death situation. I think that you would be well advised to update that to the version that the Washington first responders are going to be used to. So I think it's going to be more effective to, when you establish a doctor in the state of Washington, say, okay, I need one of those pulse forms, and get one that the first responders are going to know exactly what it says and what it does.
And we had two comments about that. One person said in Oregon, it is also a post form. So thank you for letting us know. And then we had another comment that said Maryland has a most form, which is medical orders for life sustaining.
Yeah. And I think we have to give props to Oregon. It's my understanding that Oregon invented it, that they were the first state to expand the DNR form to have a lot more information, and Washington quickly followed, and I believe the other states have followed. But I think we have to give Oregon credit for being the first.
Quite interesting. Another question, someone asked, moving from Oregon, will their documents need to be updated? I think you answered that.
I just answered that.
Yeah.
Not unless your wishes have changed. A related question to that, I often get asked if it is okay for an agent on a power of attorney or an executor to live in another state. And that is just fine. In this day and age, and especially with everything we've learned about working remotely, it's absolutely easy for your agent to live somewhere else. We've even had, sons and daughters who live in other countries, and there the only difficulty gets to be time zone differences. If it would be difficult to, reach them in the middle, what would be the middle of the night for them. But it does not matter where your agent lives.
And then another question, one person was wondering, can you get power of attorney forms without seeing a lawyer, or do you have to go into the lawyer for those forms? And a follow-up was, if not the forms, can you at least get the information without going in to see a lawyer?
Okay, so this is one of those situations where you're asking a lawyer for a lawyer's opinion. We think it's better to see a lawyer. There are forms available online. Some of the situations that we've had to fix have been people who got forms off the internet and didn't really know what it was they were filling out, and may not have done it correctly, may not have included all of the powers. One of the areas where we see that a lot is the internet forms generally are not good enough if someone later needs to apply for Medicaid. There's a lot of things that those online forms just don't think about. So we do recommend seeing an attorney. Another advantage of seeing an attorney is you can do a power of attorney even if you have a diagnosis of Alzheimer's or a similar condition, as long as at the time you're signing it, you understand the document that you're signing. And so that's something that as elder law attorneys, we do on a regular basis. We meet a couple where they don't have powers of attorney, and now one of the spouses has gotten a diagnosis of Alzheimer's, and they're told they need to get documents. You're going to have that extra layer of protection in terms of that document being bulletproof if the attorney met with the client, explained the document, got the signature, notarized the signature. Then if somebody later comes back and says, I don't think this is a valid document because they didn't have capacity, you've got a lawyer as a witness. So I think that if it's a situation like that, and basically it's, if you want my opinion is that you should get the documents done with an attorney.
Great. Thank you, Janet. Another question, somebody asked, they're living in Oregon, but we can make this a little more general. If you're living out of state and planning to move to Washington, can you see a Washington attorney?
I think that it probably makes the most sense to update your documents after you have residency in Washington. It has to do with my license. I can't do a power of attorney for my brother who lives in California, even though that would be convenient for me to do that, because that would be practicing law in California. So it depends on where you're a resident. It's easy enough for our folks. We have tons and tons of snowbirds in this area. So if you have one home in Washington and one home in Arizona, I can do your documents for you because you have a residence in the state of Washington. But I think it probably makes the most sense to, your Oregon documents are going to transfer and be fine. But if you're going to update them, probably makes sense to do it after you move.
Okay, great. Do power of attorneys require witnesses?
They do not. The current law specifies that a power of attorney can either be notarized or have two witnesses. But for certain purposes, like using that power of attorney to sell real estate, it needs to have the notary certification. So we think that in every case, it's just better to have the notarized version.
And then we had another question, a gentleman asking if their son from New York, can hire a professional fiduciary to dispose of their stuff and help with the paperwork.
Absolutely. We work with people all the time. There are many, many types of resources. You can hire the fiduciary company to do everything. You can hire organizer, junk removal people. You can hire daily money managers who, say your son's your power of attorney, but you want someone to come to your apartment once a month to help you pay your bills. You could hire someone who is called a daily money manager who could help you with that. There are just all kinds of resources available, and in this day and age, the baby boomers particularly are used to hiring and delegating. We can't all do it all, so that's very, very easy to do.
Okay, great. Well, thank you so much for your time, Janet. If anybody has any other questions, remember we'll be sharing Janet's contact information, so you can feel free to reach out to her directly with your questions. So that's not your last chance to get them answered. And so since we have no further questions, I think we're just about ready to wrap up. Thank you again, Janet. We really appreciate your time, the information you provided to us. And just remember, we will email a recording of the webinar out to everyone with Janet's contact information. Typically, you'll receive that recording usually by the end of the week or early next week. So keep an eye out in your email for it. We'll also include a survey sheet that we'd like you to fill out and tell us about your experience today on the webinar and let us know how we did. We'd love to hear from you. We're interested in hearing your comments to make this experience even better moving forward.
Thank you for hosting.
Yes, on behalf of University House Wallingford, where life goes on and lifelong learning thrives, thank you for joining us today. Wishing you a good day and good health. Thank you.
Thank you.
Thank you.